Ladies and gentlemen, it's my big pleasure to welcome our next visiting professor at the Collegium Intermarium here in Poland, in Warsaw, Miss Professor Lina Papadopoulou. She's from Greece. She's our distinguished guest here during this beautiful month, April. Our guest, Lina Papadopoulou, is the professor of constitutional law. She's teaching at the Aristotle University of Thessaloniki. She's a holder of Jeana Monneta Chair of European Constitutional Law and Culture and Academic Coordinator of the Thessaloniki University, Jeana Monneta Center of Excellence on European Constitutionalism and Religion. Her main teaching at the law school includes constitutional and European constitutional law and European human rights law and gender issues. She also teaches at the master's programs, bioethics and medical law and religion, geopolitics and international security. Lina studied at the University of Thessaloniki. She finished her bachelor on 1993. She completed her LLM in Trier, and she finished also PhD in Hannover. She completed also political theory at the London School of Economics. It was her Master of Science degree. She was a postdoc Marie Curie Fellow in the field of European constitutional law at the LSE and also University of Thessaloniki. Her primary areas of expertise include national, comparative and European constitutional issues and human rights, focusing on democracy and political parties, economy and the constitution, equality and non-discrimination, religion and the state, and bioethical issues also. Her publications include monographs, handbooks, as well as approximately 100 articles in Greek, English, and German. So today's topic of today's lecture is called Multi-Level Protection of Human Rights in Europe. It is about the role of the judges. It is about the proper way of judging, what the proper judge should use, what kind of tools should he extend to. In specifics, she will be talking about the European Court of Human Rights in Strasbourg and the Court of Justice of the EU in Luxembourg. So, once again, thank you very much for joining us, and thank you for your time that you are here and you agreed to present your topic here. Thank you. The floor is yours, and we are hearing.
Thank you very much, Alexander. And I would like to, I don't know if, can you see the, yes, it's here. Thank you very much. So, first of all, I would like to thank everybody who is responsible for my being here. It's a pleasure and an honor to be here in Warsaw, in Poland. And this is an open lecture. It is a lecture that is destined to be heard by everybody, not only experts. So it will be starting from the very basic things, and I will try to discuss these with the audience. But first of all, from Thessaloniki to Warsaw, where I come from. It's in Thessaloniki, in northern Greece. I've made the trip, and it's worth, because Warsaw is a very beautiful city. And although Greece does not actually belong to the countries of the Intermarium between the three seas, the Baltic, the Black Sea, and the Adriatic, nevertheless, I think that if you draw a mental line from South Adriatic to Black Sea, the line would be on Thessaloniki. We will be on the line, on the borders. So somehow I could say that we are also between those three seas. So now, multi-level protection of human rights in Europe. I will try to explain a little bit all these terms, but as a matter of fact, you will see that I will rather throw more questions than I will answer them. And I'm afraid this is one of the difficulties and maybe also one of the beauties of the law as a science, as a social science, and as a normative science. With law, we can very hardly find the truth, and I refer to the triangle of values of the Collegium Intermarium, truth, goodness, and beauty. So sometimes we cannot find the truth with social sciences, but I think we should strive to find the goodness in it. We are going to speak about human rights. So first of all, what are human rights and why do we care about them? So we speak about human beings, and there we might remember the words of Apostle Paul to the Galatians, where he said that there is neither Jew nor Greek, slave nor free, male nor female, for you are all one in Christ Jesus. So these words were really revolutionary when they were heard. Maybe they're still revolutionary today, because it is a declaration of equality, of equal dignity of every human being, of non-discrimination principle. In this short phrase, you can find the non-discrimination principle based on ethnicity, on religion, on color or race, on gender. So this is a declaration that even today can lead us to the principles of equality, equal dignity, and equal enjoyment of human rights. And it is revolutionary even today because we still know that there are, unfortunately, discrimination and even persecutions. Christians are being persecuted in other areas of the world. We had Christians even killed last year, more than 2021. And fortunately, on our motherland, on Europe, we don't have such persecutions based on religion or on color or race, but we still do have discrimination. And I will be happy to speak with our students also about the non-discrimination principle in our continent, in Europe. Of course, these values of equal dignity for all human beings that started as Christian values, they have now been transformed to something that is called law, legal traditions, political and constitutional culture, our European constitutional culture. Some people even say, Carl Schmitt actually talked first about it, that today's constitutional notions are not but a political theology. They are theological notions that have been actually made political. Of course, you can also find many theories, also the theory of natural law, which says that it is natural for each human being to have these rights and this equal dignity. But of course, everything rests, after all, on our decision to safeguard these rights and to safeguard equal dignity, no matter of religion, no matter of color, sex, gender, sexual discrimination, or disability, and etc. So, human rights are really based on this doctrine. It is a doctrine. Maybe we cannot prove it with the tools of the physical sciences. It is a doctrine that every human being, no matter what, has equal dignity as everybody else. Here the equality is a typical and formal equality. It's not a proportional equality. Everybody has his or her dignity, no matter what they deserve, if they deserve to get a position or not, but equal dignity means formal equality for everybody. And this equal dignity is based on our human essence. And that's why human rights are conceived as universal rights, despite the fact that they are not protected everywhere on the planet, unfortunately. If we want to dig a little bit deeper and seek for the fundaments, for the foundations of human rights, then we will find several foundations which nevertheless lead to the same conclusion. You can start for the original theology, for religions. All people, all persons are God's children, and that's why they have equal dignity and equal rights. You can also go to a more, let's say, Kantian perception, which is based on rationalism. All human beings are equal because we all share this rationalism. We can all think freely, and that's why we deserve to be free. But of course, you can also use another political philosophy, utilitarianism. It is good for everybody. It is better for everybody to respect human rights because it leads us to a happier life. And then, of course, you can also find another foundation. I would say that it can go back to another philosopher, Hume, who actually insisted that we should rather base ourselves to empathy or to sympathy, if you want, to love to the other persons. And that word, love, brings us back maybe again to theological doctrines and to the words of Jesus Christ concerning love the other person like you love yourself. And this is very important when we speak about human rights and equal enjoyment of human rights for everybody. But then, of course, although what I have just said might sound very familiar, although it is not in other corners of this world, there are still questions that we cannot answer with a yes or a no. For example, when does a human being start to exist? Should the embryo enjoy the same protection of his or her life? So what about abortions? We can say there is not a fundamental right to abortion, but there is a fundamental right to develop one's own personality. So how can we find the fair balance between the right to life, maybe not of an embryo, but of a fetus? So after the 8th week, you don't have an embryo anymore, you have a fetus, so you have some organs that start to develop. So how can you combine with the free choice of the woman who carries this fetus? And what about all this talk about wrongful life? If a society decides, society decides to acknowledge that there is no wrongful life, they should also do something more about that. They should take care of the social system, of the social services, in order to provide every human being that is being born a life in dignity. So it is not enough to say that every life is worth, which is totally true, but we should also care about every life that is really a life in dignity. And then again, we have the other side of the spectrum. What about the dead bodies? What about after we die? Is there a human dignity there? Does a dead body have rights? It sounds a bit absurd, but still, human dignity accompanies us even after we die. The way we treat our deads is a matter of culture. But of course, here again, thorny questions arise. What about transplantation, organs that are transplants, and we desperately need them in order to save people who are still alive? How can we deal with that thorny issue? Again, you might have a collision of rights, as you had it before. How can you find the fair balance between the necessity to find more transplants? Can we go ahead and decide as a society that unless you state otherwise, your organs will be offered to anybody who needs them? Can we say that? This would obviously serve the human rights of the patients, of the living people, but would this serve the human right of the people who are dead and maybe who did not express their wish not to be donors? Another very difficult issue that has to do with human rights and with the collisions that we very often have between different human rights of different bearers of human rights. And then, why do we speak only about humans? What about animals? If we speak about human rights, do we exclude animals' rights? If we use the Kantian foundation, here the animals do not have any rationalism, they do not have any common sense, they do not share the mental abilities that we share. But on the other hand, if you go and use empathy as such a foundation, then maybe the question arises whether we should start to recognize some animal rights as well. And there, of course, you still can have collisions, you still can have clashes of different fundamental rights. What about the slaughter of rights in a non-painful way, and the ritual that some religions want to have when such slaughters take place, for example? Again, difficult questions that we should discuss in more details in our societies. And after having discussed the notion of human or humanity, then I go to discuss a little bit the notion of rights. So what does that mean? Why are human rights, or in other words, fundamental rights, so important for our societies? And what about their inalienable character? So when we speak about human rights or fundamental rights, as opposed to normal, let's say, civil code rights, then the main characteristic is that no majority can take them away from each and single human being. So they are inalienable rights, and each person is inherently entitled simply because she or he is a human being. So there you have, again, a contrast, a possible contrast between a majority wanting to take away some rights and the doctrine we spoke about concerning equal human dignity that insists that there are human beings and these human beings have inalienable fundamental rights. which should be universal, or ideally speaking are universal, and should be egalitarian, and we should actually take all the necessary measures in order to safeguard these. Of course, these rights are not enough if they exist only within the nation states, because everybody knows that nowadays it's not only the nation states that exercise power, but it's also international organizations and especially supranational entities like the European Union. So it's not a surprise that especially after the Second World War and the atrocities and the tragedies we saw then, there has been a big effort to guarantee human rights at an international level, starting with the Universal Declaration, of course, but also comprising other international covenants of human rights. And of course, not only state is bound by those rights, but also private persons. Because again, nowadays we live in an era where power is being exercised not only by public entities like the state or the European Union, but also by private agents who sometimes are even stronger and maybe more dangerous than states themselves are. Speaking about rights and fundamental rights, more specifically, of course we can see that there are different categories of such rights, starting with civil and political rights. Civil rights mean the freedom from the coercion of the state, so we want the state to stay away from us and leave us free to develop our own personality and make freely our choices. And political rights, which mean that we exit this private sphere, we go into the public space, we communicate with all the other people there, and we try to find solutions that are the best for us all, for the general interest. So this means democracy, this means political process, free discussion, free speech, political parties, voting, etc. So this dimension of human rights deals essentially with liberty and participation. On the other hand, of course, these are not enough. What can someone do in his own private sphere or in the public sphere if he or she does not enjoy some basic dignity in living their lives? So that's why we need economic rights, social rights, or even cultural rights, which serve the persons when they work or when they don't work because they are unemployed, when they produce, when they are ill, when they need to go to school and learn something in order to be able after that to develop their own personality, because how could somebody develop his own personality if they don't have access to free education, for example, which is a social right? Or how can somebody actually participate to political life if they don't have a minimum standard of dignity in their lives? So economic rights, social rights, and cultural rights. And cultural rights are also very, very important because we are not only material beings, but we are also mental and psychic beings. So we need the culture in all its different dimensions as ethnic culture, subcultures, arts and science in order to flourish and enjoy life. That's why even if there are some differences between those categories, which you can possibly see in the slide. For example, when we speak about civil and political rights, then these mean freedom, whereas economic social rights, they mostly base themselves on equality principle. Civil rights mean freedom from the coercion of the state, whereas social rights mean rather that the state has a positive obligation to provide with services. Civil and political rights do not cost very much, but of course not that they're totally free. the state still needs to provide with, let's say, police or courts, etc. But obviously the social rights and economic rights presuppose more and higher resources. Then it is easier to have social and political rights heard before the courts, so they are easier justiciable rights, whereas social, economic, and cultural rights rather have a political programmatic character, and they are being implemented in a progressive way rather immediately. Nevertheless, we do have good reasons to challenge this division. For example, as I have already implied, freedom requires both types of rights, and equality must be assured in both types of rights. You cannot really distinguish and split the two values, equality and freedom. Actually, we should rather speak, and I think our constitutional traditions, our common European constitutional culture is based on equal freedom rather than only freedom or only equality. Besides that, both types of rights, they do produce an obligation for the state to respect, protect, and fulfill all of these rights. And I will come back to these obligations in more details in a while. And as I said before, even civil and political rights do cause some expenses for the state. They're not totally free. So no matter which civil right you might think of, even if you think, as I said before, about safety, about habeas corpus, or about free and the liberty to go wherever you want, you still need money to be invested by the state for roads, for police to protect you against other persons who might want to harm you, to harm your life or your security. So they are not for free. And even social and economic rights, especially when combined with a non-discrimination principle, they also become justiciable. So it's harder, but it's not that it never happens, that you can't go to court and that you can ask for a social right, especially when you are deprived of it, whereas at the same time some other persons do enjoy that same social service or social right altogether. And after all human rights do have a hardcore, an essence, a nucleus, which should always be protected and implemented. So that's something that actually is common to both types. That's why we can only have the picture as a whole, and that's why we speak about the indivisibility and interrelatedness of human rights. Human rights, no matter what, they are indivisible and they are interrelated, because it doesn't make any sense if you have all the material resources but you're not free to develop your own personality, and on the other hand, it doesn't help you if you're free but you're so poor and deprived of all the resources, if you don't have free and good public education, if you don't have public hospitals, and if you don't have a safety net for when you are unemployed or when you're not being paid very well. How could you then enjoy the civil and political rights? And now, as I have already promised, I go to the notion of the protection and the obligations, the duties that the state actually has as claims because of the fundamental rights guarantees. So here, despite the fact that, as I said before, civil and political, civil rights especially, mean primarily abstention of the state, keeping the state away, nevertheless, already this is not enough. It's not enough for the state to respect the rights, to not interfere directly with people's rights. But the state should also protect, because as I said before, it has to develop all the possible resources, services, and whatever it takes in order to protect the persons from attacks by other persons. So the state must stop others from interfering with someone's rights. And this is also already a positive obligation, not only a negative one. And of course, the state must build the legislation, so must vote for the legislation, but also for the institutions and the norms to realize every right. Here, of course, one can also think not only of the courts, but also of the independent authorities, who are very precious in our times to also safeguard human rights, but also to build other kinds of institutions like the ones I referred to, for example, social security or public health, etc. I have already referred to non-discrimination principle. It is a horizontal principle that has to do with the protection of all the rights. And as I said before, the non-discrimination principle combined with the social right makes the social right easier justiciable. So non-discrimination means that the state should be, let's say, blind towards some special characteristics that should not play any role when it comes to the enjoyment of human rights. And then, of course, adequate progress. One has the right to a fair trial, but also the right to be heard before the authorities. Participation, which means that people must be able to participate in realizing their rights, even civil rights or social rights. It's a good sign for a democratic state when it hears the citizens and its inhabitants not only during the elections or through the elections or via the elections, but also between the elections. So participative institutions, deliberation with the people is also part of their rights. And of course, effective remedies when you have violations of human rights. And that's why, because of all these institutions, I mentioned courts, I mentioned the independent authorities, it means that we do not only rely on our representatives, we do not only rely on the popular sovereignty as it is expressed via elections every 4 years, for example, but constitutional democracy involves also substantive guarantees like the ones I've already mentioned. And this means that our constitutional democracy of today is not a one-dimensional regime, but it is a mixed regime, because it mixes the procedural majority principle on the one hand and the substantive protection of some minimum guarantees for a good life on the other. And this reminds us of Aristotle's theory about the 6 different forms of government. As a matter of fact, Aristotle was not the one who first spoke about the 5 of them. Already before Aristotle, other Greek philosophers had talked about the 5 of them, about tyranny and monarchy, about oligarchy and aristocracy, and about democracy. Aristotle's novelty was actually that he added a 6th and preferred regime to the 5 ones which were already known before him. And he divided the regimes between the good or correct or ideal ones and the deviant ones. And there, according to who rules, to whom sovereignty belongs, the division is between tyranny or monarchy, where there's only one person ruling, when the few rule, then you might have oligarchy or aristocracy. And when the many rule, then you might have democracy, or, as I said before, the ideal regime for Aristotle, which he called polity. I'm not the first in political philosophy and the history of political philosophy to accept that actually this sixth kind of regime, the sixth form of government, the polity, is actually what we have today. Nevertheless, Aristotle himself had said that even the thing that we vote for our representatives and we don't select them by lot, through lot, a lottery, it shows that there is an aristocratic element in democracy. So when you combine some aristocratic elements like voting for our representatives, or having courts or independent authorities, or having meritocracy in our societies, then already you introduce some elements of aristocracy into democracy, and that makes the regime a more balanced one instead of having only procedural democracy without any further guarantees. So, in this equilibrium that we might to achieve the best regime, we can see that it's the parliaments as the representatives of the people, and maybe the people themselves through, let's say, a referendum or some other direct democratic tools, that they set the law. They have the right to decide what the law should say in its society, in its state, as long as parliaments have been democratically elected and they express the will of the people. But this is not the end of the story. The second dimension of constitutional democracy, of polity as the best regime, is that we have some guarantees, let's say, contra-majoritarian, what the Americans call checks and balances. So courts mostly play these roles as checks and balances towards majoritarian democracy. And there, of course, courts are not unlimited, because they need to base their reasoning on the Constitution and, of course, to follow the decisions of the constitutional legislator. And, of course, here, needless to say how important the independence and impartiality of courts is in this constitutional democratic regime. So if we try to find how this balance is being struck, how these checks and balances, to use the American term, work, we should say that the legislator expresses the majority, as long as you are in a democratic state based on popular sovereignty. So there you have the majority, the majoritarian principle, whereas courts should rather base their decisions not on the majority. They are not bound to follow the majority. They are not bound to follow what is considered sometimes to be the common sense about justice, or to follow what, let's say, the media, or nowadays even the social media, think about a case, but they should think based on their best knowledge and free conscience, based on the doctrine that they are there to protect the Constitution, they are there to protect the rights of each individual, and to strike the fair balance when they have collisions between rights, having already in mind, nevertheless, the public interest. And it's the legislator who first defines what the public interest is. So they come, the legislator and the court, from two different directions. The legislator sets the political goals. The court should not have political goals, but of course they are there to interpret the constitutional texts and help the constitutional texts keep their validity, to keep their life, let's say, not to become obsolete texts without any meaning for today's life. So the courts should take human rights into consideration by providing a wider space for freedom. Ideally speaking, their ideal, typical role is actually there to protect the individuals towards the majority principle. And of course, the courts cannot reduce the rights that have been provided by the legislator. So the legislator and the courts should meet somewhere, whereas they come from different directions, and the fair balance is somewhere between the public interest and the human fundamental individual rights when there is a clash between them. It doesn't mean, of course, that there's always a clash, because the legislator, when they legislate, they think about the general interest in an ideal polity, but of course they should take into consideration as well that they legislate within a constitutional framework and they cannot do anything against that. And on the other hand, the courts should, of course, protect individual interests and rights, but they should always keep in mind that there is a public interest that should be served as well. So this fair balance is always something dynamic, is something that we should discuss about, and of course we all have the right to criticize both the choices of the legislator but also the decisions of the courts. And then I go to the last part of my lecture, which is the multi-level characteristic of the protection in our Europe, and more specifically in our European Union. So here we have these three systems: the national constitutions, which are being served by the national courts, and of course the European Union law for the member states of the European Union like Poland, and of course the European Convention on Human Rights as a common instrument which has created or is creating all the time, because it's a dynamic process again, a public space of fundamental rights throughout the European continent. And as you can see, I put the European Convention above not only the national but also the European legal space, despite the fact that we all know that the European Union has not acceded to the European Convention on Human Rights yet. It might happen in the near future. There are still discussions, there are problems, but nevertheless, the court, the Strasbourg Court, the European Court of Human Rights, has found a way to say that member states, even when they act as agents of an international organization, name it the European Union, they're still not free from their obligations resulting from the Convention, which means that member states, even when they realize European Union law, they're still bound by the Convention and they can still be brought before the court because of a violation of a Convention right. Of course, here we can ask ourselves what is the relationship and what is the level of protection offered by these different human rights regimes that coexist in the same place at the same moment. Two articles of the Charter on the one hand and the Convention on the other hand might direct us to give a reply. Article 53 of the Charter reads, and I'm reading, "Nothing in this Charter shall be interpreted as restricting or adversely affecting human rights and fundamental freedoms as recognized in their respective fields of application underline that, respective fields of application, by union law and international law, and by international agreements to which the Union or all the member states are party, including the European Convention for the Protection of Human Rights and Fundamental Freedoms, and by the member states' constitutions. And on the other hand, the European Convention, again Article 53, safeguard for existing human rights reads, and I'm reading the article, nothing in this convention shall be construed as limiting or derogating from any of the human rights and fundamental freedoms which may be ensured under the laws of any of the high contracting parties or under any other agreement to which it is a party. So here we can see that both regimes, both supranational cartas of fundamental rights, they declare that they leave space for what is best, for what is the best or the highest level of protection. Nevertheless, there are some principles that might guide us to this direction. And when it comes to the European Union law, the most important principle is the principle of primacy of European law, which actually sometimes goes against what Article 53 promises, because according to the Court of Justice of the European Union, primacy law should not be challenged, should not be undermined, should not be jeopardized when it comes to application of EU law. And on the other hand, concerning the European Convention, we have the subsidiarity principle. The subsidiarity principle has both a substantive and a procedural dimension. Procedural means that you should first go to the national courts, you should exhaust the national means, and then you have access to the Strasbourg court. And substantive means that first the national courts apply the national constitutions, and if the individual has not found the solution that he desired, he can then go to the court, and of course the national courts, that's why they're also obliged to read and to know the case law of Strasbourg and take it into consideration when they judge about cases that have come in front of them. On the other hand, of course, if there is no European consensus on the matter, national margin of appreciation emerges. And there, national societies and national states who are closer to their societies have the first and last say. Of course, these principles cannot always solve the problems, especially the principle of the best protection of human rights. What does that mean when we have clashes? When you have a clash, as we have said before, let's say between the right to life of the fetus on the one hand and the right to free development of one's own personality on the other, or the clash between, let's say, the freedom of speech and on the other hand, the right to private life. When you have such clashes, the subjectivity of anybody judging and the subjectivity of anybody of us, no matter if we are judges or not, comes into the fore. And that is what causes actually this impossibility to find sometimes the truth or to find what is right or wrong, because there are different opinions based on the same texts, is what makes, as I have already said from the beginning, and I'm now closing my presentation here, by arriving again to the point that I have started from, to say that the legal science, although it is a science, but a social science, is very much connected to subjectivities, is very much connected sometimes to philosophical or religious or political or ideological starting points which sometimes shape our legal opinions. And in this framework, of course, the national subjectivities, the national Besonderheiten, if I have to say it in German, the particularities, the national particularities, may be taken into consideration if we are within the framework of the European Union by basing our judgments on Article 4, Paragraph 2, namely the national identities. Of course, the national identity is a European Union legal notion, as it is enshrined in the treaties, and that means that what counts, after all, is the dialogue between the courts, the dialogue between the parliaments, if you think of the subsidiarity principle, for example, within the European Union, the dialogue between the citizens, between political forces or political parties. After all, the dialogue between human beings is what counts most. Thank you very much for your attention.
Thank you very much, Ms. Professor. That was my pleasure to hear this. It was very thoughtful, very fruitful to us as lawyers, as people who are interested in politics. And well, let me emphasize these words of gratitude here. It was important for us because of the eye of constitutionalists and political scientists who's very focused on these matters. So it was very inspiring. And also, I think you showed us what exactly every judge should consider when it comes to the legal cases, when he stands with the cases, especially in hard cases, because you know, all of this philosophy, all of that, you know, when he is focused on consideration, human rights, and so on, that's very important questions you presented us. So thank you once again. It was very nice to hear you. Also, as a part of our, you enriched us as a Greek person from Greece, which is also, you mentioned, is a part of our Intermarium family of the countries. So thank you very much. Thank you, dear guests, online and here for your attendance, and see you on the next lectures of the Collegium Intermarium. Thank you very much.